Tantor Audio, a division of Recorded Books, presents Who Owns This Sentence? A History of Copyrights and Wrongs by David Bellos and Alexandre Montagu. Narrated by David Bellos. About this book. One of the authors is an intellectual property lawyer with a first degree in comparative literature. The other is a professor of comparative literature and the translator and author of a number of books. They came together 5 years ago to explore the relations between copyright and culture, to teach students about it and to learn from them. This book aims to continue the work of the course and to share it with others. It is not a law book, though we would like lawyers to listen to it too, nor is it a practical guide to the intricacies of copyright law today. It tells the story of a relatively simple idea, that authors have rights in the works they create, which, through many strange and startling twists and turns, has come to frame and to constrain a wide range of things that we do, for the benefit not of the many, but of the few. Epigraph. The law doth punish man or woman that steals the goose from off the common, but lets the greater felon loose who steals the common from the goose. An Old English rhyme. Chapter 1. What Copyright Means. On December the 16th, 2021, Sony Music Group announced that it had acquired the rights to the work of then 72-year-old singer-songwriter Bruce Springsteen. The New York Times reported that the sale price was around $550 million. Mozart was not so lucky, nor Ray Charles for that matter. The reason why a catalogue of songs and recordings can now be sold for the price of a fleet of small aircraft is the whole subject of this book, copyright. What copyright means to the purchasers of Springsteen's life work is the entitlement to a license fee for all uses of the singer's work as sheet music in translation through broadcasts of old recordings and the streaming of new ones and so on, until the end of the 21st century. As Sony has surely laid out less than it expects to get back, the tax it aims to extract from the global audience of Springsteen lovers over the next century must run into billions. What copyright means to you and me, on the other hand, is that the bulk of modern and contemporary culture, I mean not just Springsteen or the Beatles, but all the films, cartoons, novels, plays, paintings, ballets, video games, computer software, telephone directories, and banana costumes, made by creators of all nations who are alive today, will not be free of licensing charges or of severe constraints on how they may be used until after your grandchildren reach retirement age. The laws that create the opportunity to sequester and exploit creations of every kind for 3 or 4 generations do not have very deep roots, and only in the last few decades have they acquired such scope, length, and power as to allow the accumulation of huge piles of money. That is why copyright now means more than it ever did before, and why we need to understand how it suddenly got to play such a large role in modern life. This book explains where the idea was first sown, how it sprouted, developed, and ramified over centuries, and then, in a short space of time, was transformed into the biggest money machine the world has seen. Yet nobody noticed. In earlier times, changes to copyright were made amidst loud and eloquent public debates in which the great minds of the age took part. In England, where the whole story began in the late 17th century, John Locke, Daniel Defoe and Alexander Pope, and then later on William Wordsworth, Charles Dickens and Thomas Macaulay, were all involved in the making of copyright. In 18th century France, the playwright Beaumarchais, the mathematician Condorcet and Denis Diderot, who directed the first comprehensive encyclopedia, took up clear and public positions. Many of the great writers of the 19th century, notably Balzac and Victor Hugo, left strong marks on the development of copyright law. But in the last 50 years, copyright has spread over the globe without noticeable intervention from philosophers or from poets, and with almost no public debate. Who among the creators of today, and who among the consumers of their works, has heard of the Geneva Convention for the Protection of Producers of Phonograms against unauthorized duplication of their phonograms? Of United States Code Paragraph 107? Or of TRIPS? Or of the Digital Millennium Copyright Act? Or of the CTEA? Yet these legislative actions, which in their combination now create the value of the Springsteen catalogue, took place respectively in 1971, 1976, 1994, 1996, and 1998. That's to say, some time after the singer from Asbury Park first picked up a guitar. These United States laws, and their global extension through international treaties, have brought fundamental changes to individuals' rights, to the privileges of corporations, and to the status, effective remuneration, and creative freedoms of artists in all fields. Why have we heard barely a squeak from any philosophers, poets, musicians, or creators in the vast range of disciplines to which these new regulations apply? The framework in which almost all forms of creation and invention are now organized and monetized worldwide has been dealt with as if it were just a technical issue, outside of political and social debate. But it is not too late to ask whether the resulting situation serves the legitimate interests of those who consume the products of other people's minds, as we all do. Modern copyright is a social construction, not a basic fact of life. Every step in its tangled history is made of words, and by virtue of the legal doctrine of stare decisis, to stick by what has been decided, each of those steps was built on what was there before. That is to say, copyright is the history of copyright. There is no other way of accounting for the current state of protection and control of the products of human minds than to tell the story of how it got to be that way. What is curious about it is that despite the vast changes in the way created things can be made and distributed nowadays, the language of copyright law remains entangled in words that were penned at its very beginning. Copyright arose in London in the early 18th century. In its first form, it gave the authors of books and their assignees a short-term monopoly on the printing and selling of their works. The types of work allowed such monopolies grew over the following centuries. Then the length in years of the monopolies awarded was increased again and again. Then the scope of copyright was extended, piecemeal, to cover more and more secondary uses, such as abridgments, adaptations, performance, translation, and so on. Objections were raised at each step, yet none of the philosophical, ethical, and practical reasons for halting copyright's forward creep ever won the day. Does that mean that the skeptics were and always have been wrong? Does it mean that, whatever the rights and wrongs of the matter, copyright is an unavoidable effect of social, industrial, and technological progress, a byproduct of modernization? These are not rhetorical questions, and the answer to each is no. In the first place, many of the negative effects of copyright law in the modern world were foreseen by 18th century critics. Their warnings were justified, but they were overruled. In the second place, copyright has obviously played a dynamic role in shaping the modern world, especially in the last half-century. It is not just a side effect of a wider, irreversible tide of history. It is one of the great forces that pushes the tide itself. But it does have a particular feature that makes it unlike other forces of modernization. It cannot help creating inequality. Many bitter struggles have been waged for a more equitable ownership of land. Great revolutions have sought to ensure more equal access to natural resources and productive assets. Parties and politicians have called for fairer access to housing, education and health. But nobody has ever thought of campaigning for a more equal distribution of copyright. That is because copyright, and its sister rights in patents, designs, trademarks and publicity, collectively known as intellectual property or IP, give the single creator the exclusive right to a rent, known by the antique name of royalty, from a work, device, service or image used or enjoyed by many. How could such rents be distributed more evenly? Their very purpose is to create inequality between the singular creator and the multiple community, between the owners and users of texts, images, inventions, names and brands, between rights holders and the rest of us. This may not have been seen as a harm, even by stalwart egalitarians, when the beneficiaries of the system were as beloved as Charles Dickens and Victor Hugo. They were few, they were great, and they were, for the most part, progressives themselves. Nobody resented Thackeray's income from Vanity Fair, or even the riches that Picasso accumulated from his art. But things are not like that anymore. Most copyrights of commercial value now belong not to artists, but to corporations. Mostly very large corporations, such as the one that bought Springsteen's catalogue. When you look more closely, you find that they belong to a mere handful of very large firms. Copyright litigation arises nowadays not between creators and pirates, but between giant corporations seeking to sequester a source of rent. The language of these legal battles has remained much the same as it was 300 years ago, but the stakes have changed. Expensive litigation now serves most often only to adjust the balance of power between financial behemoths charging decades-long license fees for the products of other people's minds. A striking example of the transformation of copyright law into a corporate goldmine was the epic lawsuit undertaken by Oracle to force Google to pay for the privilege of using limited aspects of the Java programming language, its application programming interfaces, or APIs, in its Android operating system. Conducted initially under patent law, the suit morphed over more than a decade into a copyright case because copyrights give much longer protection than patents do. But copyright law, couched in a long-standing terminology of authors and works, was so ill-suited to the squabble that district and federal courts gave inconsistent and incompatible rulings from appeal to appeal, until the whole matter, which had already cost tens of millions of dollars in legal fees, was heard by the U.S. Supreme Court. In April 2021, the highest authority did not even give a ruling on whether or not APIs could be the proper subject of copyright. It only decided that if they were, then the specific elements of Java that Google repurposed would not have infringed the owner's rights. Some observers counted this as a victory for the public interest, since it limited a rights holder's grip on the secondary uses of its property. However, the ruling does not answer the question of whether or not a language can be owned by a corporation. Despite its vast extent and labyrinthine detail, copyright is not settled law, and its history suggests that it should never be allowed to settle without vigorous public discussion. Otherwise, a small number of large corporations will end up owning everything. In medieval Europe, everything belonged to God, and was therefore, in the gift of a sovereign, empowered to divvy up God's creations by granting privileges over them to his lieges. Over centuries, the religious foundations of feudal monarchies crumbled. First the rights of the barons, then of commoners, and eventually of the people, came to fill the space grudgingly vacated by the crown. Over the last 50 years, the historical trend from exclusive to distributed ownership of property and rights has undergone something of a reversal. In no sector is this more obvious than in the way we now treat the products of the mind. Copyright initially promised control of a small range of created works to the creators themselves. However, in the transition from an agrarian economy to the industrial and then the information age, the value of intangible assets has come to eclipse the value of land, plant and machinery, and all other kinds of material wealth. As a result, the handful of corporations that now control most intellectual property of substance strut the world stage as the new barons of the 21st century. Today, 6 of the largest corporations in the world, Apple, Microsoft, Alphabet, Amazon, Meta, and Disney, each having a larger capital valuation than the gross domestic product of many of the world's nations, are almost entirely constituted by their ownership and control of copyright material, partly in the form of content such as films and songs, as with Disney and Amazon, partly in design registrations and patents, as with Apple and Microsoft, and mostly in the form of computer software, as with Alphabet and Meta. The empire of IP is the feudal domain of our day. The recent history of copyright, therefore, cannot be fairly seen as part of the growth of personal freedom and individual rights. In fact, the opposite view of it would be nearer the truth. The changes made to copyright laws in the later part of the 20th century have been called the New Enclosure, after the Acts of Enclosure that between 1604 and 1914 put almost all the common land of England into private hands. The commons of today are not the green fields and village ponds of yore, and the geese we consume are not made of feathers, flesh and bone. The poor yokels we are nonetheless have to cough up subtly hidden taxes on the immaterial goods that we enjoy. Woe betide any who trespass on the vast estates of today's corporate squires. This book tells the convoluted story of how that situation arose and considers some of the real risks that it brings. An immediate concern lies in the emerging field of artificial intelligence, or AI. Machine learning algorithms now allow computers to create music. There is already an annual international competition modelled on the Eurovision Song Contest for music produced by AI. Very soon, maybe already, piped music in supermarkets, alongside background music in films and television series, as well as hits to be played on mobile devices, will be generated by no human creator, but by a machine. Who owns these tunes? Copyright laws do not currently answer the question, just as they do not tell us who owns the text produced by automated web-based translation systems. The owners of the copyrights in the computer code that generates such music, and increasingly smooth translations, have tried to claim copyright in the outputs of their devices. In the United States, the owners of an image capture system lost their suit against Disney in a district court, but in China, the owners of an AI program that produces automatic market reports in English have been granted copyright over the automated reports themselves. In the near future, AI will most likely provide simulations of many other activities that up to now have always emerged from human minds, and it will do so by processing pre-existing material protected by copyright. The outcome of appeals in cases of this kind will have a huge impact on relations of power and money around the globe. If a handful of large software corporations that own copyrights in AI programs are to be allowed ownership of the services and simulations those systems create, then we will all be in their hands for ever and a day. The role of copyright in promoting inequality has rarely been tackled by economists, political theorists, or historians. Karl Marx, who was working in the British Library during a period of intense discussion of copyright and patent laws, does not mention intellectual property in his deconstruction of the reign of capital. That is probably why there is no major left-wing critique of copyright, and it may explain why Thomas Piketty also omits discussion of intellectual property in his surprise bestseller Capital in the 21st Century, which appeared as recently as 2013. The irony is that Piketty has done very well out of the issue he does not discuss. The copyright in a book that has sold more than 2 million copies worldwide has generated substantial royalty income. As the great majority of the copies sold were translations of the work, Piketty's windfall derives not only from copyright itself, but from an extension of its scope that was first made in just a handful of countries in 1886, in the United States in 1891, in the United Kingdom in 1911, and in Russia, China, Albania, and many other nations in the 1990s. So only in the 21st century could Capital in the 21st Century have produced the capital that its fortunate author now has at his disposal. Piketty's case is admittedly exceptional. The vast majority of writers, composers, artists, and programmers accumulate little capital, and some of them get no income at all from their creative work. Copyright's effects not only mirror, but also contribute to the phenomenon that Piketty seeks to analyze in his book, the yawning and ever-growing gap between the wealth of the few and the poverty of the many. Copyright, when it first arose, was held by many to represent a more equitable balance between the power of a small cartel of wealthy printers and the rights of the creators who provided the raw material for their trade. However, to understand how literary property eventually turned into an engine of inequality, we must first look back to the ways in which the rights of authors were conceived in societies of the distant past. Chapter 2. Authors in Antiquity. Copyright is not the foundation of all the rights that authors have over their works nowadays. It's the other way round. Without ancient traditions of authors' rights, copyright might never have been invented. In the 4th century before the Common Era, the Athenian philosopher Plato set up an academy where he taught students through conversation and dialogue. One among them, Hermodorus by name, took copious notes. When he returned to his hometown of Syracuse in Sicily, he had his notes copied and then published as a book by Plato. Hermodorus was not a plagiarist, as he did not pass off the book as his own work. Nor was he a thief, since he had not made off with anything that belonged to Plato by the laws of the day. Yet Plato was outraged. He thought Hermodorus contemptible by disregarding an already established rule that granted authors the right to decide if and when to make their work public. Hermodorus had infringed a code of honor. The right of authors to decide when and how to share their work lies at the heart of numerous disputes among authors and publishers in the ancient world. Cicero, for example, complained forcefully to his friend Atticus that one of his works had been published without his knowledge or permission. Galen of Pergamon, Diodorus Siculus, and Quintilian grumbled along the same lines. In a society that had no conception of ownership of the contents of literary or philosophical work, it was clearly understood that taking someone else's writings without permission to make books out of them was a dishonorable thing to do. Copyright laws now incorporate the rule of conduct that gives authors the exclusive right to publish their work. Because of this, some have argued that copyright itself is so ancient as to be a natural and personal right. But that is to put the cart before the horse. authors' rights in the ancient world did not make their work a property to be owned, and claims made by some modern scholars that ownership of intellectual property has always existed are simply wrong. Equally misleading are claims that intellectual property was invented in Sybaris around 500 before the Common Era, where, according to a much later account, a cook who invented, and I quote, any peculiar and excellent dish for the annual banquet at which women were allowed to be present, was to be entitled to all the profit to be derived from the manufacture of it for the following year, in order that others might be induced to labour at excelling in such pursuits. But a closer look at the origins of this story reveal it to be an ancient joke, touted as an explanation for the decadence of a city-state devoted to excessive luxury. They were Sybarites, after all, and which was wiped out by its neighbours from Croton in 510 before the Common Era. There is no need of modern copyright law to make publication unauthorized by the creator an improper act. 5 centuries after the Plato affair, Hermodorus remained a common synonym for bounder or cad, in the same way we call a miser a Scrooge and a hypocrite Tartuffe. A further right enshrined in copyright systems of the Anglo-American and European kinds is the right to be identified as the author of a work. No one may claim to have written a work save the person under whose name it appears. This concept also predates the invention of copyright by a couple of thousand years. We know about it mainly because of the ruckus that arose on the occasions when it was seen to have been infringed. However, judgments of an offence most easily captured by the term plagiarism, though it's also more and less than that, have never been as simple as judging infringements of the right to make a work public. Greek writers of comedies regularly accused one another of plagiarism. Roman authors also discussed the question of where adaptation turns into theft. Was it acceptable to take several Greek plays and rework them into a single Latin comedy? Or to take part of a Greek drama already reworked by a Roman author and to use it again? The decisions reached in each case were not made in the courts or negotiated in lawyers' offices. They were not matters of law or money, but questions of proper conduct, attribution rights, and their corollaries in disputes over alleged thefts of creative ideas do not require the legal superstructure of copyright law to exist or to be resolved. Honor codes did just as well for all but 3 centuries since the invention of writing itself. In many American universities today, rules governing students' graded work also rely on a code of honor, often called just that, the Honor Code. Despite what some college handbooks say, rules of good conduct in writing term papers do not derive from copyright laws, but from concepts of good behavior that were current in the ancient world. For Aristophanes, Terence, and Cicero, among many others, what was more unacceptable than excessive borrowing from past and present authors was the failure to acknowledge the sources used. For Pliny the Elder, veteres transcribere ad verbum neque nominatus, which means copying old authors word for word and not naming them, was akin to theft. That kind of misconduct came to be called plagiary, from a Greek word meaning kidnapping originally of someone else's slave. Plagiarism is not an offence created by copyright. In fact, the tediously lengthy US copyright law of 1976 and the even longer UK copyright law of 1988 do not use the word once. A student can plagiarize her professor's ideas, arguments, and evidence without infringing any copyright, whereas there are many ways of infringing copyright that do not involve plagiarism at all. For example, broadcasting a song without a license, or giving a public reading of a book you've downloaded onto your e-reader. Many people find the borderline between plagiarism and infringement difficult to grasp, but it is important to realize that they are historically, formally, and...
Sample complete. Ready to continue?